Okay. Yeah.
I ran into one of your former adversaries, but Mr. Andreski.
Oh, you did?
He was like, "So whatever happened?" And I'm like, "Well, he played for 30 years." And he said, "Somebody finally got him dead."
Yep. I never thought he was going to play. I was shocked. I really was. His wife was shocked too. She didn't know.
Okay, let's go ahead and get started today. I want to get this on time and give you plenty of time to ask any questions that you may have. So we will do a moderated Q&A for about 40 minutes, and I'll turn it over to you at 5:40 or 5:45 so you can ask questions. We should have a microphone. If we don't need the microphone, if you can project, then we'll play that by ear, but we want to give you plenty of time to ask questions. First, thank you all for being here today. We want to make this fun. I know that some of you are here through extra credit. Some of you are here because you're interested in law enforcement or pre-law. We hope that we will have something for all of you. But we also don't want you to think of this as kind of a stuffy panel. So we're going to have a little fun on the panel today. And if you have any questions, you can ask them. But if you just feel like they absolutely have to be asked at the moment, then raise your hand and we'll try to get those answered at that moment. We have first, we've got this in a specific order, but we have with us Paul Smither, Professor Paul Smither. Some of you may know him as a professor, but he's also had a career as a police officer for the Houston Independent School District. We'll talk a little bit about what that means. He's also been an investigator for the Harris County District Attorney's Office, and he is now in a career as a professor here at Sam Houston State University, where he got his master's degree. We have Darla Faulkner, who got her bachelor's degree at Sam Houston State University in criminal justice. Went to law school, Texas Wesleyan. That was in Fort Worth, just and is now Texas A&M Law School. And she is a Montgomery County prosecutor, and she has tried everything from misdemeanors to capital murder cases. And then we have Judge David Moorman, who is a district court judge. David Moorman took an unlikely path through law school by majoring in agricultural economics. Is that right?
That's correct.
And that just shows you that there's not a magical major for law school, if some of you are considering that. His father taught at Sam Houston. He went to A&M for his bachelor's degree and ended up going to Baylor Law School. But he came back and practiced law for 20, 25 years, and then was elected district judge. So he tries all the felonies in the state of Texas in this area. 3 counties, is that right,
Yeah.
Judge Moorman? So we are going to kind of walk through this process of a crime and pinpoint how a case would go through the criminal justice system. But one thing that I want to highlight that may not be as obvious to you is, as I was kind of looking at their biographies, each of them has sort of found a community, and that's some of what you are doing in college. So your grades are important, the organizations you involve in are important, letters of recommendation. But if you were to talk to Paul Smithers 30 years ago when he was getting his bachelor's degree at University of Houston downtown, and told him, hey, you'll be teaching at Sam Houston where you got your master's degree, I'm not sure he couldn't have predicted that. And Darla Faulkner, who grew up in Huntsville, lives in Huntsville now, but practices in the fastest growing county in the United States to the south of us in Montgomery County. She may not have known. She may have at one point said, I got to get out of Huntsville. But she turns out that the relationships she's made play a role the rest of her life. And that's also true of David Moorman, who also grew up in Huntsville, went to law school elsewhere, but came back here. And his upbringing and his college qualifications helped get him deserving of election. So I want them, when appropriate, if you can talk a little bit about the community as we go through and discuss your careers. But something I want you all to think about as well. But let's begin, and I'm going to kind of come around here. Can y'all hear me okay? So let's just kind of take a case that you guys might have heard about from some of your friends or just from the news. And that starts with, we'll say, a DWI on, what do you think, what night of the week here in Huntsville? Thursday night. That's actually what I was going to say. So Thursday night, 2:15 a.m., and Professor Smithers used to be a street crime police officer. Now, he actually did a lot of that at HISD. What does that mean? Do any of you know what does that mean? If he is a police officer for the Houston Independent School District, what crimes fall under his jurisdiction? Anybody? Hunter? So students who have drug possession, is that what you're saying? Yeah, that's a great answer, and that would fall under it. But not just the students.
Teachers, custodians, PTO presidents, PTA presidents, staff members, anyone that works for a school district in any capacity whatsoever falls up under my jurisdiction as a police officer. It can be anyone that comes on the campus that do not belong on the campus still falls under that jurisdiction.
And this is actually, some of you probably know this, university police have an unusual jurisdiction. So you probably know that UPD for Sam Houston State have jurisdiction in any county in Texas where Sam Houston leases property. So if we have a billboard that says a great name in education in El Paso, the UPD can make an arrest in El Paso. So Smither, in his experience as HISD police officer, will have experience with street crime. Later, we will pull him in as an investigator for a district attorney's office. But that's a separate stage of the process from right now. So let's say you are a police officer for a municipality, Mr. Smither, and you see someone swerving, you have probable cause, they don't turn on a blinker to turn. So you need probable cause to pull them over. Is that correct?
That's correct based on the traffic violation. I have to have PC, probable cause.
Okay, and they'll use that phrase, PC. You pull them over, you have reason to believe they are intoxicated. What are your options at this point after you have pulled them over?
Well, at that point, I need to continue the investigation because right now I have a traffic stop. I have probable cause, reason to believe that the person is under some influence of some type of drug or something. So at this point, there's several, I'm not going to go through all the cues because it takes a lot of time. There is a actual process that officers have to go through to actually develop more probable cause that that person is actually driving while intoxicated. Once I get all those facts, and it has been determined based on several tests and cues that I've given that individual, then I have to contact the district attorney in Harris County. Now understand, depends on what county you're in. In Harris County, you must contact the Harris County DA's office. In some counties, you can actually just make that charge and make that arrest. But let's say Harris County, I'd have to contact a district attorney by phone and provide them with all the information, starting from the PC stop to everything I have, and actually request for them if they would actually pick up charges for the DWI, if that is what the case is.
Okay, and let's assume that this is a person who is a CJ major at Sam Houston, and they have taken courses on this, and they know that when you ask them to blow into a tube, they can at least for the beginning say no.
Yes.
So what do you do when they say no?
Well, it depends on what time of year it is because they have some instances where we call it a no refusal weekend. In certain situations, you cannot actually refuse if it's a no refusal weekend. But if you decide that you do not want to blow and I still have all these other cues that I have, then as I said, I will actually converse with the district attorney to see where we want to go from this point.
And Ms. Faulkner, does Montgomery County allow for refusals?
No, not in Montgomery County. In Montgomery County, we get a blood search warrant in every case, unless, I guess I will say, unless there is a true exception, like for safety, or there's some sort of reason that we just logistically can't get one. But in Montgomery County, it's no refusal all the time.
And that is also true Walker County. So I don't know how Montgomery County does it, but the police officer actually has it's like email, sends a judge who will wake up at any hour of the night, look over the warrant, sign it. You said no, but that now gives the authority to continue the investigation. And that continued investigation can be saying, you have to blow or we're going to take blood.
Yes,
And then that goes into evidence.
absolutely. Yes.
And if they resist you taking blood, they now are resisting arrest,
Now they're getting additional charges put on them as well.
and you're still getting the blood.
Yes, absolutely. We're going to get it one way or the other, you all. So it's just up to that individual on how much force they want to put up. But you're only making things more worse for yourself and severe once it gets into the criminal justice in the court system.
Now, if you don't blow, they can still bring charges against you. It may be more difficult. They have to use other evidence from the in-car video system or their body cam or you slurring or the officer's testimony of you smelling like alcohol. But it does probably become more difficult. In this scenario, we're going to assume that the student actually blew and blew a .12. Do y'all know what that is? What's the legal limit? 0.08. That's right. So it's not crazy. This isn't the kind of blood alcohol level where Darla and her people go around going, "Can you believe this?" But it is over the legal limit. So it is now the police officer, the police department is submitting that, is referring those pieces of evidence to the district attorney's office. Ms. Faulkner, tell us where you take it over and what you look into.
So in Montgomery County, we have a similar system as Harris County in that we get contacted right from the street. So police officers on the side of the road, they're making that decision to arrest, they contact our office. So we become involved at that point. We set a recommended bond. Then the case is going to go to a magistrate, and our prosecutor is likely going to be assigned that case 3 to 5 days after the arrest. That prosecutor is going to review the information that they currently have, but at that point, we're really waiting on law enforcement to submit their entire investigation to our office so that we can start reviewing everything and we can make an initial offer, a plea offer for the case.
So do y'all make a charge based on, do you make a charge based on the original evidence or do you wait on that?
No, we make a charge that night. We have prosecutors that work 24 hours a day, 7 days a week, and they're creating the charging instrument, at the same time that the arrest is being made. So once the arrest is made, we receive information from the jail and we create the charging instrument at that point. If once we get the entire investigation, if we need to amend that charging language, then we will, but typically it's not necessary.
So think about the evidence that they have on hand right now. They have the blood alcohol level. They have the officer's testimony. They may have some evidence from the car, but they're waiting on some other things. So one thing might be witnesses. There were people in the car with them. They're getting witness testimony together. Can you subpoena their financial records?
We can. So if, let's say, the officer has an interview of the suspect and they say where they were before, so they were at this bar, then we will likely subpoena the records from that bar to try to get the receipt or, information of how much that person drank. And then based upon information that we could have maybe from that, as far as like if, I guess you could subpoena a credit card if you needed to. It just depends on the facts.
How about text messages?
For sure.
So he's texting people and going, "Man, I'm so drunk."
Right.
That's just devastating in a courtroom.
Correct. That is.
And now this is a tricky question, so I'm giving you that alert. What if you asked any one of these students, hey, we're going to get your phone and look through every one of your text messages, they probably wouldn't like the I'm so drunk, but there's probably a lot of other things that people text message that they don't want read. Is that leverage for the DA's office? Even though it may not be evidence in this, but
Leverage for what?
well, there's just a prosecutor going, oh, let's see, you texted 6 females that night. That's interesting. That's embarrassing to them. It could have an impact on their relationship.
True.
Is that fair game in an interview with a defendant?
I mean, I doubt that it's going to be really relevant in this charge, but it definitely could make, I think, depending upon what's in someone's phone, and if it could be relevant to the case, it could make a person want to plea versus take a case to trial and have their wife hear text messages about, some sort of affair or something like that, I guess.
Or what if
But I don't
there's
know
other
about
illegal
leverage.
activity?
True. If
So
there's
the
some
day
sort of
before
illegal-
they bought weed, they have,
True.
would y'all have access to that based on, or would you only be able to subpoena 3 hours worth of text messages?
So if we're gonna do a search warrant to get into someone's phone because we have probable cause to believe that there's evidence inside that phone that goes to that case, then we are gonna have that phone. I mean,
see.
it's kind of everything.
Okay, so that's,
Now, sometimes what we do have is defendants that will consent to give you a certain amount. Like they'll say, can I give you pictures of these texts and that be sufficient? And sometimes we'll just be like, yes, just consent to that. And then that way we're not taking the phone and dumping everything.
okay.
So it just depends.
So you've got the .12, you're waiting on additional evidence, and that's still, in this case, Paul Smither is wearing the municipal cop hat. You're still the lead investigator, or are you turned over, you were the street cop, then an investigator is doing additional research, turning that over to the DA. Then you have an investigator, which, Mr. Smither, you have also done as part of your career. So if you have worked for the Harris County District Attorney as an investigator, assuming he was working for you, Ms. Faulkner, in Montgomery County, how would you work together to get additional evidence and or prepare for a plea or trial?
It would obviously depend on the case file that we receive. Most important thing that we're going to work together to make sure is that we are able to provide the defense attorney all of the discovery in the case. And we trust that law enforcement is going to provide that to us, but often, we're missing something. And so my investigator will help me to obtain everything that's in the case. And then anything extra. So our investigators spend a lot of time really focused on punishment. So we think of our trial as the guilt innocence phase is like a picture, and then our punishment is like a photo album. And so I want everything. I want to know everything about this defendant. And so my investigator will help me to get school records or prior criminal history information from other counties, offense reports, prior judgments, just any information. One time I had a DWI where it occurred from a wedding. Somebody got intoxicated at a wedding. My investigator helped me to go find the wedding photographer who had all of these amazing pictures of my defendant drinking. They help in any way that we need them, and then they'll help us to prepare closer to trial as far as serving our subpoenas for us. And they'll sit with us in trial to kind of just to be someone to help us gather our witnesses, evidence, that kind of thing.
Mr. Smither, anything to add to that as part of the investigative process?
What's real important is that it's a team effort when the district attorney, investigator, and the prosecutor team up, because it's very, very important, because majority of the time the prosecutors are in trial or they're in court. So they do not have a lot of time to get those additional things that may have been left out by law enforcement. At times, there are cases don't go to trial 2 or 3 years later, but we can't find the witness. The witness is missing, the address has changed, so it's important that the investigator are able to use all those resources, as well as have relationships with other agencies so that we can get those things that the prosecutor needs and the defense need to be able to put on a very fair and equitable trial. In other words, like I tell the investigators that I supervise, we are what you call the gophers. What I mean by that, whatever the prosecutor needs, we make sure that she have whatever she needs so she is well prepared to present that case and to seek justice for not only the family, but also for the state as well. The relationship is just like a husband and wife. They work very close together. They work long hours together. They take them to crime scenes. They're pretty much their security blanket, and they actually act more security when they're in court, when they're going out on scenes. We can go on and on with the responsibilities and the duties of her investigator, but it takes too much time to do that. But we are the gophers. Whatever we need to make sure we have complete all the evidence, because at times things are left out by the local agency, and it's our responsibility as criminal justice as a whole to make sure we have all the evidence. Like ADA Faulkner said, we have to have all the evidence, and we have to present it all. We can't leave out bits and pieces. We cannot go to the judge and say, we don't have that, judge. The defense didn't get that in time. We don't have the results of that blood draw. We have to present everything that we have, guys, and it's called discovery. Because if we do not, then we're just being unfair to the defendant, making sure that he has a just and actually fair case.
And so one other thing, they mentioned the term local agency. This can actually be a wide variety, and maybe not even local. So it could be a school police officer. It could be the local city police officer. It could be a county deputy sheriff. In fact, probably about 97% of the cases are going to fall into one of those local government areas. But it could also be a DPS. And in Walker County, I don't know if this is still done, Judge Moorman, you may, but our DA used to, once a week, meet with different law enforcement agencies around the county. And so he would sit down and go through some of the cases and then might talk to somebody. And this pertains to something that Ms. Faulkner said, which is if you happen to be, your sister's getting married and you just drank too much, and you don't do this very often, but your sister was getting married and things got out of hand. She may handle that .12 very differently than if she hears from the investigating officer that I see this student every Thursday and Saturday night. Usually they're in the passenger seat or at a party I'm busting. That's going to be a different plea bargain and maybe different charges, or at least a different penalty phase than what it would be for the person who was celebrating something that's hopefully once in a lifetime. Is that true?
I agree with that.
And sometimes you will have people bring letters from professors or pastors or all sorts of things. Can that make a difference, or is this just manufactured friends?
Are you asking me?
Yes, I'm asking.
I believe that it does make a difference. I mean, that's any sort of mitigation, and good defense attorneys are going to get that mitigation evidence. And, you know, again, we're looking at the whole person, and especially when we're talking about DWI, I mean, good people get DWIs. I mean, that's not one of those offenses where we think they're monsters or something. I mean, it's everyday normal people get DWI. So anything that we can receive to kind of know that, like, this person is a productive member of the community. They have a job, they have a family, they go to school, anything like that is helpful for us to be able to make a decision ultimately as far as a plea offer.
Judge Moorman, when you were in private practice, did you ever defend a DWI?
Oh, yes.
And so what was the first advice you gave? Again, a .12, somebody who didn't hurt anybody, there's no accident that was involved. What's the first thing you tell that student to do before you get to meet with the DA?
Well, you want to gather all the information you can to explain why you can get the best outcome you have. And part of that is, what's your school record? What are you active in? What are the positive things about you? Because all the prosecutor knows at this point is, on this date, you were arrested, you were driving while intoxicated, and, putting yourself and other people at harm's way. And so you need to come forward with the best things you can about, are you an Eagle Scout? Do you volunteer at the pet shelter? Are you all the things we can to put you in a different light? The first thing I would say, though, is, okay, look, this has happened. You can always make your situation worse. As bad as you think it is right now, what you need to do is realize you've got to change your conduct, okay? You've got something serious that's pending. Don't go out and party. Don't go, no alcohol. You need to lay low, take care of your school, everything else. You probably need to tell your parents if you hadn't already told them. You think you may be able to hide it and keep it from them, but there's going to be some errant piece of mail that might show up at their house, and then all of a sudden they're going to find out and they're going to know. So, sometimes folks don't take that advice. And the next thing you know, something else happens, and the DA really thinks that there's somebody they need to throw the book at.
And just to put a number on this, Jack Choate told me once, several years ago, he was the assistant district attorney. He said that they'd had people look at this, and a DWI, not an attorney's cost, but when everything is put together, it costs about $35,000. So it's not just the attorney's cost, but it's the increased insurance rates. It's the ultimate expunction if you can get a deferred adjudication. It's the court cost. It's all the things, the bail. And so these things can be very costly, even though they happen sometimes to good people every single day. They can be very costly to you, even if it doesn't ultimately result in a conviction. Now, DWI, you get so often, you have a pretty good system for plea bargaining that out. So the first thing, what percentage of all cases end in plea bargain?
I'd say 95, 97%, something, a very high percentage.
And so with something like this, where there's not anyone hurt, there's not extenuating circumstances like drugs in the car, it's a .12, what are you probably going to offer the defense team?
We're probably going to offer, again, it's hard to not know everything, but one of them, I would say mostly we would probably offer a straight fine and court cost in Montgomery County. We typically don't offer probations until it's a second because we have so many of them. So we would offer a fine and court cost. So $1,500 fine and court cost. We could also offer deferred if the defense requested that. Also, depending upon, their age and, I guess kind of our mitigation evidence, they would have an opportunity to potentially file for a pretrial diversion. So there's a lot of options. But a standard offer would be a fine and court cost for a Class B DWI.
But that goes on their record.
It does.
And so then the defense may come back and say, no, he needs a clean record. We want a deferred adjudication.
Or we want a pretrial
diversion.
And so they'd have to apply for all of those things to really in order for us to give that pretrial diversion, or even really to make a deferred. You don't have to apply for it, but you would have to request it.
And is that considered a plea bargain?
Yes.
And does that have to go before the judge and be approved?
Yes.
Does the judge?
A deferred does.
Would you, based on what you know, one of the reasons they're nervous about answering my questions is they don't want you coming out of here thinking, I'll get a deferred adjudication. So every case is different.
Correct.
But based on what you know, Judge, would you approve a deferred adjudication for a .12 with no major extenuating or mitigating circumstances for a one-time offense?
So when they come to me, I only have jurisdiction over DWIs involving somebody being a passenger 15 or under, which would be a state jail felony, or a DWI third. So at that point,
And the plea offer would be very different for
the
that.
plea offer is very different. And so,
So the reason that this is the case, put yourself in the county court at law position for the moment. County court at law deals with misdemeanors. District court, where Judge Moorman is, deals with felonies. So this case would not have gotten to him. But if you were county court at law judge, would you sign off on that plea?
yeah, so part of this is, I don't really know anything about the case unless I did a search warrant or something. So I'm relying upon the representation of the district attorney. And if they say this is what we think is a good resolution and the defense has agreed to it, it's probably going to be approved. Now, if there's something I know about it that makes me nervous, then I may go a little bit further and say, Ms. Faulkner, is it an opinion of the DA's office that this is a plea bargain in the best interest of Walker County? And you're recommending that I do that, because then at that point, go from there. But I'd say when you have people taking pleas, probably 98.9% of them in the county court of law, they're accepted on the misdemeanor level.
So that's going to be most of the cases, as you said, a plea bargain. However, there are some that go to trial. So let me just ask, Ms. Faulkner, how many times are you in trial per year? Before you became the division leader, how many times did you go to trial per year?
Trying to think. We have 50 lawyers. I would say the average is probably 3 to 6 times for a prosecutor each year. We have prosecutors that are in trial every week, but we have 55 prosecutors. So you spread that out, and that's kind of what it ends up being.
So one of the misconceptions.
Cases, though, every week.
What's that?
You're preparing for cases almost every week.
And Judge Moorman actually did work as a municipal prosecutor, actually before the municipal judge. So he's at defense, prosecution, and as judge experience. But okay, so there's cases that you are preparing. Let's say a plea bargain for this case falls through. How do you prepare for trial, and what do you the first thing you know is who the judge is? How does that affect how you prepare for trial?
It doesn't affect how I prepare for trial, no. I mean, I want to prepare the best that I can, so I'm going to review everything that's in the file. I'm going to take video notes and know everything that is said on all of those videos. I'm going to meet with my witnesses. I'm going to meet with my arresting officer. I'm going to meet with my analyst. I'm going to meet with, if you have like a 911 caller or some other kind of witness, I'm going to meet with all of them prior to trial, prepare my exhibits, anything that I think could be interesting to a jury so that I can keep their attention while I'm trying this case. And then I'll start working on my voir dire for jury selection, my opening statement, my closing, my direct examinations. So just preparing everything that I can for trial, and then using my investigator for various aspects of that as well.
Ms. Faulkner, we had a conversation before where she gave me some information. Depending on the county, when you come in and they call a baby attorney, when you're a beginning prosecutor, you're dealing with a lot of misdemeanor cases, and your caseload may be...
It's very high. So like in Montgomery County, we have we have about 10,000 misdemeanors a year, and we have 3 misdemeanor courts. So each of those courts gets 3,000, 3,500 cases a year, and that's split amongst 3 prosecutors. Really split among 2 with a chief prosecutor that's taking a very small caseload. So when you start as a baby prosecutor, you do have a very, very high caseload.
Could be 1,000 cases a year. You told me that after 5 years, when you're starting to deal with felony cases, it's more like 200.
Correct. So as you kind of promote through the office, at about the 5-year mark, you're probably a felony, we call it a felony 2 prosecutor, where you're mostly handling kind of secondary felonies and higher, mostly victim cases. Unfortunately, most of our felony 2 cases are child sex cases. So the volume of those decreases, so they have a lot fewer cases than our misdemeanor people do. We have about 6,000 felonies a year. But the severity of the cases and how difficult they are and how much time they take to prepare, it takes a lot more time.
And so it gets to court. And Judge Moorman, what is your role? You are the judge, and so how are you going to preside over this? What preparation do you need to do? And maybe you can tell us a little bit about what some of the misconceptions about being a judge there are, because people, when they learn that you're a judge, you probably get some immediate responses.
Well, first thing I'm going to do is, probably like Monday, I'm going to have a docket where I'll pick the cases that are going to trial. And so what I'll know about that is, number one, which ones have been on the docket for a while, are people in custody, and basically kind of sort through all the lawyers, trying to make sure that they're actually ready for trial. So the last thing we want to do is bring a jury in and have somebody show up that morning and say, we didn't get the blood test back, or this witness isn't available, or we can't get the toxicologist, or the defense show up and say, the defendant's mother came to me Friday and brought me information about that he's had some mental health problems, and I really need a mental health expert to make sure that he's competent. I just thought he was just mean to me, but she's brought this, and now I think he may have some competency issues, and so we've got to get that tested. So the last thing we want to do is have that happen at the last minute, and I've got 110 people show up for jury duty, and then I have to tell them it's not going to happen. And so as I get ready, once we know for sure which one is going to be the first case, number one, make sure I know what the charge is, what the range of punishment is, that we've got everything taken care of, that there's not going to be, I like to take care of like all the motions to suppress before we start the jury trial. If somebody wants to challenge the video or wants to challenge the search warrant, that we take care of those before we actually bring the jury in. But the morning of of the trial, I'm kind of responsible for making sure that we've got everybody there, making sure that the rights of the defendant are protected if they're in custody, that the jury doesn't see them in shackles or in the jail uniform as they're coming in, that they see them in street clothes, that it's not telegraphed that they're already in custody, and then make sure that as we go through the trial, that it's handled appropriately.
And have you ever been in a case, Mr. Smither, where at the last minute we're in trial and they call you and they need clarification on evidence or new evidence to be gathered?
Yes, that happens on multiple occasions where there may be something that come up at the last minute. There may be something that has happened, and as law enforcement, as DA investigators, as I said, we have formed partnerships with other law enforcement agencies. So we may have to get something that we need right away. We may need to get a subpoena served right away. We may have to do this writ of attachment like right away because the witness have not shown up. So that's why it's so important, like DA Faulkner said, that DA investigator is in court during that time. When a prosecutor is in trial, the district attorney investigator is in trial as well. He is there to provide her pretty much any and everything she needs. We usually sit right behind the ADA that's prosecuting the case. So all she has to do is turn around and give us a note. I need this. And when she does that, I need it like right away. Instance I had one time in a murder case, the witness did not show up, and the district attorney turned around and said, I need you to find him. I need you to get him right now. I got up and I went did what I was told to do and tracked that person down and got that person in there. So at times, yes, things do come up in trial, and the prosecutor expects for her investigator to actually be there and provide that. There's no such thing that I'm going to try. They don't want to hear I'm going to try. They want to hear it's going to be done. That's all they want to hear. Thank you. That's it, right? No, that's all you want to hear, right? You don't want to hear a whole bunch of excuses. Just get it.
That's true.
That's true.
And we don't have reciprocal discovery in Texas, so the prosecutor has to give all the discovery they have to the defense. The defense doesn't have to give us discovery. So there are times when opening argument is when we actually are starting to realize what their defense is even going to be. And so that may trigger us to think, oh man, we may need this or this or this. And so we're kind of pivoting and trying to get our investigator to save us.
I once had a prosecutor tell me that if they turned to their investigator and said, I need a goat. If I need a goat for my closing argument, go get me one. The appropriate investigator's response is, what color eyes would you like the goat to have? So it is not okay to say, a goat. You say, what color eyes? How tall? What's the weight? And it's necessary for the functioning. Now, I want to kind of close with a couple of questions, because a lot of people, when they go into law enforcement or the legal system, they think of themselves as doing good, helping people, but they are also elected or political figures. So, Ms. Faulkner, you are an assistant district attorney. You work for the district attorney, who is an elected official.
Correct.
Does that create any job insecurity for you every 4 years when there is an election, especially as you've moved up the ranks?
I mean, definitely. So, like, if thankfully my boss has not had an opponent in the last couple of elections. So, but until that last day where you can sign up to run, that is always stressful. I think larger offices can withstand changes a little bit more, but the higher you kind of get, the more chance you are that you would lose your position and have to go do something else.
Would you ever run for office?
No, I don't think so.
You're ruling it out.
I think I'm ruling it out.
Did you ever say that, Judge Moorman, that you would never?
I have so much respect for the people that do, but I think that I don't know that that's for me.
So when you run for district attorney, to become a district attorney, you have to run for office. You are now a county official with state authority. When you run for district judge, you are running for office unless someone retires midterm, as just happened in Walker County. Otherwise, you have to run for election. If you're appointed because someone retired, then you either have to run again, you have to run for the new term, or sometimes a special election is called. Judge Moorman, did you ever think that you would run for office? Is this something you wanted to do?
It wasn't, I guess it's one of those things as you go through your career, you start thinking about it. When you're young, you think all these people that have these positions, you're like, oh my gosh, they've gone through some special training and this, that, and other. And then when you get out and practice or get in a profession, you realize they've got some experience, they've got some time. But as you go through that yourself, you can be on par with those folks to handle those positions. And one of the things that drives you is, at least me, to run was, you want to make sure the job is done right and done appropriately. And I would rather run than have to think about somebody that I didn't think was going to do it appropriately, handle a position. And so it's not, even when you run unopposed, I mean, I have 3 counties, so I knew some people in other 2 counties, but I spent a good bit of time going and introducing myself and meeting people in other counties. You're only in there for 4 years, and so you've got to run every 4 years. So you like to think if you do a good job, that's enough, but you also need to make sure that you're present in the community and people know who you are, and you can kind of judges are difficult because you can't really say what you are or aren't going to do if elected, but you want to say that you're going to work hard to make sure the justice system runs.
And we mentioned that Judge Moorman is a district court judge. So if someone is convicted or acquitted in his court, if one of those attorneys appeals, it goes to, in Walker County, it goes to the 10th Court of Appeals, which meets in Waco. But once every year, they come to Sam Houston State University, and with the collaboration of the Criminal Justice Department, we will meet in here April 16th. So if any of you are interested in the appeals hearings, are any of your rulings being appealed? Do you know?
No, I think one of Judge Sorensen's cases is being appealed. I mean, I had somebody complaining to me about the commissioner's court was going to hear something that maybe they thought they didn't do right. And I'm like, look, the cases get appealed. It's got my name on it. They write in writing what they think I did wrong, and then they decide if it was harmful or not. So, you know, don't go into being a lawyer if you don't have a thick skin, because prosecutors, defense attorneys, they'll say, well, you didn't preserve the error correctly, or you did something inappropriately. They'll say the judge did something inappropriately, and they're going to put it, they'll be nice about it. They won't put your name in there, but everybody knows who it is.
So that will be in about 2 weeks in this room at 10 a.m., 11 a.m., and 1:30 p.m. Judge Moorman, we hope you can make it. But let's turn it over to questions from the audience now. And would y'all be willing to take a group picture at the end? And anybody, and you'll hang around until you get tired of hanging around. So I think they'll take some questions now, but also maybe we can orchestrate a group picture at the end. Some of them may do some small group Q&A afterwards if you want. But let's take some questions from the audience. I think we have a microphone for anybody who wants to ask a question.
Don't be shy.
Hello, my name's Jayla Perry. First, I would like to say thank you for coming out to Sam. Really appreciate the opportunity to hear you guys' stories and all the things that you have done for the community. My question is, what is a pre-trial diversion?
It's kind of like a special type of probation that you receive in order to not, in order to kind of divert the charge to where you don't get a conviction and it's not in your criminal history. So it just kind of helps you to not be convicted of a crime and kind of gives you that second chance.
And Jada, that was a very nice introduction. So you represented Sam well. Thank you for that professional question.
Let me piggyback on what she said. And with that pretrial diversion, what it does, as ADA Faulkner said earlier, it gives individual, because sometimes we make mistakes. It may be your first time making a mistake, but it helps us to give you that pretrial diversion because we want you to get back in society. We want you to be able to make a positive contribution to society. So if you get that pretrial diversion, you made one mistake. Now you have an opportunity to do something positive rather than put you in the jail system, rather than put something on your criminal history that's going to stop you from being a productive citizen, from getting a scholarship, from being able to get that job, to get an apartment or anything like that. So that's why that pretrial diversion is very beneficial for someone that's well deserving of that, because the point of the CJ system, we want individuals to be effective in the community. But if you have that criminal history, it's hard for you to move forward. So we do everything from the pretrial diversion to make sure that you can be a positive influence in society.
Can I add something to that as well? And, you know, I always told clients the pretrial diversion, it's a contract between you and the DA. If you perform what you're supposed to, then their side of it is they'll dismiss the charge. You won't have conviction on your record. And then you can go through the process of basically expunging that record where it's erased. The jail will destroy the photo they took of you when you were arrested. The DA will destroy their file. The clerk will destroy their file. And anybody that works for the government, it would then be a crime for them to disclose that you were arrested and here's a copy of their offense report. And so that's a powerful opportunity. And, you know, in this area with young people away from home, there's a lot of folks that you may not make the best of decisions all the time. Now, that doesn't mean those things are handed out like candy. You have to work very hard to get that kind of opportunity. And, you know, the world is different now than it was when I grew up. I mean, there is a much more permanence to things. There is everything is on the internet. And so what may or may not happen may be out there for the rest of your career that you're having to face with, and it may prevent you from taking tracks that you want to do, especially if you're a CJ major.
Ms. Faulkner, was pretrial diversion just recently allowed in DWI cases?
No, pretrial diversion, deferred is more recent.
Okay.
We used to not have the ability to give a deferred adjudication for DWI, but pretrial diversions, I think, I could be wrong, but I think pretrial diversions have been around for a long time.
Yeah, it was the deferred adjudication. So at one point, MAD,
Correct.
Mothers Against Drunk Drivers, so many deferred adjudications, which is very similar to pretrial diversions, were given out that MAD was able to lobby and get a law passed. So actually, if you were accused of murder, you could theoretically get a deferred adjudication. But if you had a DWI, you could not get a deferred adjudication.
But there is a difference with DWI deferreds is that you can use those prior deferreds to enhance a DWI if you were to get another one, which is different than other deferreds.
More questions? Good question, Veda.
Well, one thing I want to add is if you have a DWI arrest, depending on which judge, they may make you have a device on your car that you have to blow into that'll take your picture every time you blow into it. And if you have alcohol in your breath, it won't start. Or they may make you carry around a handheld device that you have to blow into whenever it gives you a signal. Or they may make you wear something on your ankle that constantly monitors your sweat to see if there's any alcohol. And if you violate that, you might find yourself in the jail awaiting trial. So, and those are, most of the time are done at the defense expense. So that's about $300 a month until your case is resolved.
It's expensive.
More questions?
For those of you on the panel that went to law school, how hard was it and what was your experience during it?
I mean, I thought law school was hard. I enjoyed it though. Yeah, I enjoyed it, but it was a lot of hard work, a lot of reading. Yeah, I feel like those 3 years were a little bit of a blur for me. It was a lot.
It's a difficult time. Intellectually, you're challenged. You're pushed. They are not gentle about the learning process. At least they weren't when I was in school.
Me neither.
It was, if you were not prepared, there may have been some public humiliation involved. So it's not an easy path. It's a rewarding path if that's what you want to do. But I always tell people, ask about it. I said, don't ask me what law school's like right now because I went before the internet. So you need to find somebody that's gone to law school with the internet and all that. It's different.
But it is actually very similar still. About a decade and a half before Judge Moorman went, there was kind of a war of attrition. So Harvard would actually accept twice as many people as they wanted to keep. And then they got rid of half over the first year.
That was true of my class too.
That was?
About half didn't make it after the first year.
Attrition today is about 5 to 10%. And so it is very low compared to prior decades. But there are two things that are important. One is the curriculum. Critical thinking and reading is crucial. That's why you should get a major or at least some courses that test that. The second thing that's just a major difference. How many assignments did y'all have over the course of a semester? Well, how many graded assignments did you have over the course of a semester?
Not very many.
Just an exam.
Yeah.
Got an exam at the end of the semester. So your job is to keep up with everything. Occasionally they will give you a simulated test halfway through, but usually you have a final. It's in a blue book. You write it out over a period of hours, and it takes them sometimes 4 to 8 weeks to grade it. So you take that in December, your first semester. You get your grade sometime in you may get your final grade at the very end of January, and you first get an inkling of where you stand in the class. That's the first time you got an assessment, is January, your fall semester. So that's just it's a different skill set that is rewarded. Our students are bright, but a lot of times they take courses that don't test those skills, and they get into sticker shock. They get there that first year and they're like, oh my God, what have I got myself into? They adapt, but that first semester can be tough if you're not used to reading, critical thinking, and self-regulating. Good question. Other questions? We got time for a couple more.
Has anyone on the panel had any interesting or difficult interactions with grand juries?
I heard grand juries.
Yes. Interesting. You said interesting interactions?
Interesting or difficult interactions?
I mean, I've spent a lot of time with grand jury. Trying to think of.
So a lot of people may not know. So a grand jury is who you provide the information to, and the grand jury does not decide guilt or innocence, but the grand jury decides whether to indict or not to indict.
Based on probable cause.
Do you have to go to a grand jury?
So in Texas, you have to go to a grand jury on a felony unless the defendant waives. So we may have defendants that plea prior to an indictment, and so they'll waive their case being indicted. But if not, then a felony case has to go to a grand jury. If they are in custody, they have to go to grand jury within 90 days, or they could be released. And then if not, I think it has to be presented within 180 days. But we present we have a grand jury that's every Tuesday and a grand jury that's every Thursday. And they serve for 6-month terms. And we go and present cases to them. We also we do investigations as well, and we'll bring witnesses to a grand jury. And yeah, I mean, our grand jurors, I think what I always hear is that they have a rewarding experience. They typically enjoy their service, and they definitely get a new perspective on what's going on in their community, for sure.
So, but the grand jury is very different, and so in some ways they're all interesting. Does a defendant have an attorney with him or her during the grand jury process?
So typically, yes, they would have a defense attorney, but like if a defendant were to come in and testify to a grand jury, the defense attorney would be outside of the grand jury. They don't have the ability to be in the grand jury, but a defendant could go out and ask the defense attorney questions before they come back and answer. But typically, defendants aren't at the grand jury. It's typically the grand jury and the prosecutor. We may present 30 to 80 cases on a Tuesday and the same thing on a Thursday, sometimes even more cases. So it is a very different process.
Well, in my 3 counties, typically they're smaller. They don't have as many cases, so they'll usually meet once a month. And I think they may return 50 indictments the last time they did.
Okay.
Walker County, but the other counties are smaller, so they won't have as many cases.
I think I saw Naya's hand for the last question.
With all of y'all's different hands-on, firsthand experience in the court system, what do you think one of the biggest misconceptions are?
I think as far as being a prosecutor, I think people think that our job is to get convictions, that maybe we have some sort of quota or that we get raises based on that or something. My job is to see that justice is done. And especially, I mean, I can only speak from my office and my district attorney that I work for. But my job is to see that justice is done, and justice could be a dismissal, justice could be the maximum sentence, justice could be a pretrial diversion, probation, a fine. It could be anything. And so we aren't just focused on the conviction. We're really focused on what's the right result, what's the right thing that should happen. And we also are really focused on the defendant and the defendant's rights, and making sure that, you know, the defendant's rights weren't violated, and make sure that that the officers did what they were supposed to do. And so we're kind of looking at it from I don't know, not just one. We're not just looking at the end result here. We're kind of looking at it from a lot of viewpoints, and we're trying to protect everyone in the process.
Well, a lot of times the prosecutors goes to great lengths to make sure that the defendant has and their counsel has everything they need. And because the last thing they want to do is have somebody and then have to come back and take it up on again. And that's part of my role, is to make sure, one, they know what they're doing. If they take a plea deal or if they're going to trial, they know what choices they're making, that they talk to their attorney, that I've got to make sure that the attorney has done the appropriate things in the case. And the last thing we want to do is to have to try something twice. That's not good for anybody involved in the process. And the last thing, I don't want to have the jury have wasted their time by having come in and hear a case and then us have to try again a second time. So I think that really a lot of effort goes in to make sure that the trial is fair by the defense attorney, the prosecutor, and the judge.
And Professor Smither, misconceptions about the investigative process or the police?
I think one of the biggest misconceptions is that because the relationship that we've seen over the past between law enforcement and the community has been kind of seared, and there's a big gap. So I think the misconception is that law enforcement is not fair. I think some of the misconceptions also is that we should do certain things that the community want us to do, but understand that we're bound by certain powers and limitations when it comes to the Code of Criminal Procedure. When it comes to the Penal Code, there's certain things within our powers that we can do, and there's some things that we cannot do. Because many times when individuals are in a crisis, they want to know, why can't you do this here? Why don't you do this here? But I think the misconception is that we have powers, yes, but our powers are limited based on the United States Constitution and the Code of Criminal Procedure, which we have to follow as investigators and police officers.
I think all of us are limited. Sometimes people think, oh, you've got all this power, you can put people in jail. Yes, under certain circumstances and certain procedures that are followed. I do think that the jury system is wonderful. I think sometimes you can see it. People have this expectation that that jury is going to, they're surprised when they get who they get, because if you've got friends or family out there in the audience, they're not going to make the jury. And so it's going to be 12 people that really don't know you, and they don't know anything about the case. And I think sometimes people have this expectation of, you know, I'm from here, I'm going to get there, and I'm going to know everybody on the jury. That hardly ever happens.
True.
Okay, I want to thank Doris Pratt, who has put all this together and doing it as a second job sort of thing, because she's actually took this over from Luke Putman, who has moved on to a different position. So Doris, thank you very much. Department of CJ for putting these great Real Talk programs on, LEAP ambassadors for helping out this afternoon, but most of all, our panelists who all have some ties to the community and have come back to help out today. So let's hear it for them. I think they have agreed in a weak moment to do a photograph for anybody who wants to come up. So we'll do a group photo. Anybody who wants to, we'll put the students in front of the table.
No memes, no memes.
The panelists can stand up behind, and then I think they were willing to stay a reasonable amount of time if you have individual questions.
I'm
Let's let
amazed.
anybody who wants to leave.
I'm amazed at all the
Anybody
things
who wants
that
to get a
people to
picture.
take the paddles and, you know, whoever was congressman holding up a paper and it's like, you know, yeah, don't hold up a sign.